I first of all want to thank Chairman Levin and Ranking Member McCain and remind everyone that this particular amendment addressing the detainee provisions passed overwhelmingly on a bipartisan basis from the Armed Services Committee. And the reason that we addressed this issue was because we heard witness after witness in a series of months before the Armed Services Committee from our Department of Defense tell us, for example, when I asked the commander of Africa Command saying he needs some lawyerly help on how to answer what to do with a member of al-Qaeda who was captured in Africa. This is an area that cried out for clarification, and that's the genesis of this amendment, which is a very, very important amendment. Just briefly, two issues. Number one, on 1031, the arguments that have been raised about 1031, the statement of authority, this is a red herring. This provision was drafted, as Senator Levin said very clearly, based upon what the administration wanted, and also really codifies existing law on what the statement authority is in terms of the fact that we are at war with al-Qaeda. And if people want to disagree with that, that's certainly a policy discussion that we can have. But we were attacked on our soil in 9/11, and this codifies the fact that we are at war with members of al-Qaeda. 1032 is the military custody provision. Let's be clear on what it does and it doesn't do. Number one, it's very clear on who it applies to. It only applies to members of al-Qaeda or an associated force who are planning or carrying out an attack or attempted attack against the United States or its coalition partners. It does not apply to American citizens. We're only saying that if you're a member of al-Qaeda and you want to attack the United States, we're going to hold you in military custody. Why? I prosecuted cases in the criminal system. We don't
Senators, 2 minutes have expired.
I would just say we don't want to ever have to read a terrorist and tell him you have the right to remain silent. That's the issue here.